Thank you, everyone who I know and those who I don't know for coming to the session today. My name is Katitza Rodriguez. I work for the Electronic Frontier Foundation, EFF, as an international rights director. Mainly, my primary work is on international privacy and surveillance issues, and our current project focuses on trying to fight overbroad, overreaching surveillance legislation that provide overbroad surveillance powers to law enforcement. And we are trying to advise policymakers, governments, but also activists and human rights lawyers how they could fight those surveillance legislation, whether at the technical level, at the legislative level, like commenting on bills, submitting comments, or at the activism level, like campaigning, etc. Because of this, today I will talk about cloud computing, challenges and opportunities that we have. First of all, I do love technology, and we are now using cloud computing to be in this webinar today. So my critics are not against the technology itself, but are the policies that are around, that are creating the situation and the way we are just using the technology, that are creating new challenges for privacy of the users and our civil liberties rights. So first of all, being said that, I did this presentation in the cloud, and we are using a webinar in the cloud. But when we are doing that, we are also leaving a lot of digital footprints of what we are doing online. So today, we are going to talk about that, and we are going to divide the session in two parts. We are going to the next slide. Okay. Oh, it's the small slide. Yeah. So the first is the challenges raised by the cloud computing environment for traditional civil liberties paradigms. And the second part of the presentation, we will which rules we need to put in place at the national level to alleviate the heightened risks to privacy and other civil liberties cloud services. So there are two disclosures I want to say. One, law enforcement need to do their work. We are not against them doing their work. We are just trying to make sure there are limitations on government's powers, so there are check and balances and oversight in place to avoid abuse of power. And the second is that we love technology. We are just raising awareness of these challenges and the policies that need to be in place to protect our rights. Being said that, right now we are moving to a cloud. There are two trends that are coming right now. First, we are relying and trusting more of our data, not in cloud providers like your Gmail, the webinar, but also we are relying a lot in third devices like our iPhone, your phone, your Android. And this means that we have to trust on the companies that are handling that data that before was in our house, in our offices, in our file cabinet. Now it's being handled by third parties. This means that if someone goes and knocks to the door, we might not be able to know that the data has been handed over, our data has been handed over to third parties. While in the past, they will go to your house and you will know, you have more control over your information. So we are losing that control. Companies can do something to do, like for instance, encrypt cloud providers, but sometimes that is expensive. Sometimes companies companies want to mine that data for advertising purposes. So there are no incentives to encrypt all the data by default. Some companies do it, some others allow it, but some others not. So there are a lot of challenges. The fact that we are relying on third companies or to handle our data in devices that are not under our control. The fact that also we are leaving a vast amount of digital footprints in every interaction we do. But also, it's not only all about companies, it's also about governments. Governments are learning what they can do and how they can mine and how they can analyze and use all these vast amount of digital footprints that we are leaving behind, whether when we are using our phone or we are using our email address or we are communicating through Skype. We anytime leave a lot of footprints. But what does it mean? Let me go to the next slide, please. Okay. Yeah, the next one. Okay. So now, what we can do with this data, is possible with all this metadata, this data that is not exactly the content of your communication, but the data that you leave behind your communications, who communicate with whom for how long, your IP address, the URL of the search you make, the search word, keywords. And so with all this metadata in several jurisdictions, and we consider its content, depending on the legislation, you can directly observe people's relationships and interactions, and even use with that data that is not the content, but allows you to make inferences about their intimate and protected relationships. With all this amount of information, it's possible to examine millions of people's communications and rapidly identify everyone in a population who has communicated with particular persons in a particular language, or even on a particular topic or with a particular vocabulary. Track a particular person's physical movement almost all the time, or almost everyone's movement. With this amount of information, you can also make inferences about professional, sexual, political, and religious activities. You can draw conclusions about religious, political, and sexual interests, beliefs, and attitudes from individuals, associations, and your internet traffic. You can also routinely retain data for decades, so that even statements and interactions that have passed out of human beings' living memory can be searched, analyzed, and recalled. You can do all this simultaneously. The fact that we are leaving much more digital footprints shouldn't entail less privacy protection vis-a-vis the government. Transactional data should not have lesser protections based on the technical details of how the data is stored, processed, or transmitted. As we have seen, all what we can do this data is really rich and can disclose much more than even the content of your communication and should warrant a stronger protection. But legislation in several countries have given less protection to the data that you have, this metadata or transactional data, than the content per se of your communication. The standard for government access to this data is lower in many jurisdictions than the content of communication itself. So, however, and despite all this, law enforcement and intelligence agencies are saying and complaining that the data is retained about people's internet use is not enough. As we more move to email or social networks or messaging or games, law enforcement are concerned that they will lose the capability to put under surveillance people that are using those mechanisms to plan and commit criminal acts. This is why some governments, for instance in Canada, UK, and the United States, are trying to pass new bills that will intercept capacity in these new internet service companies. These mandatory backdoors, let me move to the next slide, please. Sorry, I didn't know it was going to be so small, the letters. Okay, so these companies, these new obligations are already exist, but it's applied only to ISPs and phone companies. Does not apply to, and some both over IP, but does not apply, for instance, to Google, Twitter, or Skype. So the bills in UK, United States, and Canada are seeking to broad the intercept capacity of these services providers to spy on internet users. So how it works, okay? I will go one step before. Right now, in the United States, for instance, CALIA or several standards in different parts of the world have obligation that compel ISPs and phone companies to develop mandatory backdoors so they can make easier to legally spy on internet users. So they already have their warrant, the court order, to intercept a communication. What the obligation compels those companies is to create a backdoor, to make it easier, to facilitate, to make it quicker, to spy on internet users. In other words, if I'm a law enforcement agency, I go to ISP or phone company with a warrant, and then the internet service provider should have developed an infrastructure or have the capacity to make easier the handover of the data on interception. But this means also creating security vulnerabilities to secure software, because you are creating a backdoor that can be exploited not only by law enforcement, but also by criminals who can exploit this security weakness and take advantage of those that loophole, that vulnerability, to use that information, that system. And this has been already a case in Greek in 2005, when hackers or crackers, criminals, broke into a Greek telephone network and subverted its built-in wiretapping features to intercept the communications of high-ranking Greek government officials, including the Prime Minister. In any case, despite these traditional law enforcement, mandatory backdoor rules, what is happening right now in UK, some proposals in Canada, but having a stall right now, and in Australia, is to expand these obligations to also incorporate companies like Twitter, Gmail, or Google, or social networks, or games, or cloud computing. Let me pass through another one. Another problem and challenge that we see that is coming is the fact of that these private-public partnerships between companies and law enforcement. So of course, everyone wants to combat crime. I mean, whenever you can cooperate, it should be fine. The problem is that there is no ways to know what's going on there. There is no oversight mechanisms. I want to explain the problem. First, we have sometimes companies that, for instance, a company will go and knock to the door. The policeman will go and knock to the door, or the law enforcement will go and knock to the door to a company without a warrant for content of communication or whatever the information they need. The law compels to provide a warrant, but in some legislations, if the company, because they're cooperating with the law enforcement, they can, and there are no legally liability for them to hand over the data voluntarily if they want to do so. In some legislation with data protection rules, there are exceptions for handover of data for criminal purposes. So how do we know when this situation is happening? Do the data protection authority in those countries with data protection authority knows about this handover cooperation among parties? Is the person whose data being sought being notified that is happening? How we can find information about how many requests is being handled and whether the purpose is legitimate and whether there is no abuse of power. Because in some countries, when you ask, for instance, an order for interception, you have to give, as the law enforcement, later a report to the Congress of how many interceptions, for which purpose you have asked this information. But in this private partnership cooperation, those oversight mechanisms and safeguards are not working. So the data flows from the private sector to the government in ways that are very opaque, secret, without notification of the users. And I think this is a huge problem. Yeah. Then there is a lot of problems also, for instance, when governments try to request data of a citizen instead of do a targeted, focused request. Sometimes they massively broaden the request to get massive communications of people's online activity and social networks. And so the measure is not proportionate, necessary, or targeted for a specific purpose that it allows them to combat crime. And how we can create check and balances. If we are a civil society, we of course want the police to protect us against the crimes. You know, we don't want criminals out there. But we also don't want that those that it's supposed to protect us end up undermining us just to catch one criminal, because sometimes the laws are not anymore, some laws, instead of being targeted and a specific tool to combat a specific crime, or they are passing legislation, which is mass surveillance legislation that allows companies to spy on everyone's users just in case they will need it in the future when they are fighting a crime. A good example of this is the European Data Retention Directive that compels ISPs and law enforcement, ISPs and telecoms to return for certain period of time the traffic data of who communicates with whom for how long, between 6 and 2 years, for possible use law enforcement in the future. So instead of ask for the preservation of this data in the case of investigation, everyone is subject to the retention for possible use. And this creates a huge risk for us and opportunities for abuse of powers. And well, we as civil society or as individuals, again, we want the police to combat the crimes, but we also want our rights to be protected. And how we can create a oversight mechanism, how we can make sure that the police actually is doing their work and not abusing its power. how we can challenge surveillance that are overbroad or illegal or are targeting activists, which is happening not only in authoritarian regimes but also in democracy. When all this debate about surveillance is just shrouded, S-H-R-O-E-D-E, shrouded in secrecy, because individuals are never made aware of what's going on because of the legal requirements. Some legislation, for instance, compels companies to not disclose that the data, they forbid the company to notify the individual if the data is being sought. This happened in the WikiLeaks Twitter investigation when Birgitta Jones, an Iceland parliamentarian, the US government sought the traffic data of Birgitta, of the parliamentarian. There were a gag order on Twitter, and so they were not able to notify Birgitta. But this company, Twitter, decided to challenge that gag order, and said, you know, we will challenge that request. I think that is not proper. We should be able to notify the user so they can find a lawyer and defend themselves. Maybe that request is not legal, it's overbroad. So they challenged in court the gag order, and they won, and that's why they were able to notify Birgitta, who contacted EFF and ACLU to represent them in court. So there is a lot of secrecy, but some companies are now starting to help to shed light a little pieces. But there is obligations not. The obligation should never be only on companies. Another example of this help from companies on trying to disclose how surveillance is working, because we don't know, and it's very hard to know how it works, is the report of that Google has developed, the Google Transparency Report, and also Twitter lately have followed Google's steps. That tells you the number of government access requests that they are making each period of time, each 6 months. And we have that for several countries around the world. We should praise both companies for doing so. But this is not enough. Even if we want it, and that's a good first step, it's not enough. We need more rules also for governments to comply with these obligations of transparency, due process, oversight mechanisms. We should avoid requests that are bulk requests just for fishing expeditions to see what they found, whether in their way of searching for information they found something that they could just prosecute. So in this kind of SE scenario, a group of civil society organizations that was the Privacy International, who was led by Privacy International, organized a meeting in Brussels and put a lot of activists to discuss the idea of develop a set of international principles of due process and government access to data online. So in this meeting, we were discussing, at least in EFF, and we organized a meeting in Baku too. We were thinking, well, we have all the guidelines and treaty on consumer privacy that provide detailed protection on privacy vis-a-vis the corporation. And it's very detailed, you have the Convention 108, you have the OECD privacy guidelines, you have the European Data Protection Directive, and 78 countries now have data protection legislation. But when it comes to government surveillance, you have the Cybercrime Treaty, and the Cybercrime Treaty provides detailed law enforcement powers for detailed surveillance, powers for law enforcement. And the protection of human rights is Article 15, which is very general. That together with the court decisions, you have to interpret what that it means. So we thought, we need more detail, more guidance for governments on how to implement these surveillance laws. Maybe they don't know, they haven't done a comparative analysis. Well, maybe they know, but maybe there are always people in government who wants to do the right thing, and they would like to learn how, what are these best practices, or how they could take into account these public accountability and oversight mechanisms and criteria to see whether a legislation is comply with human rights standards. So taking into account the human rights standards, we developed a group of people, privacy advocates from different countries. This is still a draft, so it's not the final principle. It's a draft that is being discussed, and everyone is welcome to submit comments. You can go to the website that is on the presentation, and you will see the draft. So we come up with this draft or set of principles. The purpose is to provide some guidance for legislative changes and the protection of communication. Communication in a whole sense. Communication as the content as well as the metadata, this transactional data that I explained earlier in my presentation that disclose a lot of our privacy information. And so we create a set of principles. Let me go to the next page. Based on international human rights standards, one is the legality principle. Any limitation to the right of privacy must be set forth by law. And this means that nor the executives nor the judiciary may adopt or implement a measure that restricts the right to privacy without a previous act by the parliament. That's included in many constitutions around the world, but unfortunately, governments forget about it, and activists are not enforcing some. I don't think there has been a strong campaign enough to start compelling governments to comply with those obligations that are at the constitutional level and international human rights law. So the other one is necessity. Laws allowing access to communications or communications metadata should be done by authorized public authorities for the purpose of either law enforcement or intelligence, and should be limited what is strictly and demonstrably necessary. Nothing about fishing expeditions here, in the sense that overwhelming positive justification exists, and it's justifiable in a democratic society for the police to comply with its legitimate obligations and activities. And because they have exhausted all the other mechanisms to investigate a crime, and this is the only way to pursue it and be able to identify the criminal. Another principle, and I think we are on time. I would like to ask Arvin how we are on time, please. The other principle is adequacy. Public authorities, I don't know. Yeah, do you hear me? Yes, I'm talking, right? Okay. Okay, perfect. So one more is the adequacy principle, where public authorities should restrain themselves from adopting or implementing any measure of intrusion, allowing access to communications that is not appropriate for the legitimate purpose that justify, establish that measure. So the measure has to be adequate, and it should be proportional. The standard for proportionality should be a higher one, which is what we see the problem with many metadata, which they want to give a lower standard. And really, to access this data, there's a need to have a high degree of probability that a serious crime has been or will be committed, and that the evidence obtained of such a crime probably would be found by accessing the communication metadata or the communications data. So it's not that you are fishing, it's just that you are targeting your investigation, and also that your traditional investigative techniques have been exhausted, and that a plan to ensure that the information collected will be only that informational reasonable related to the crime, and any excess information collected will be promptly destroyed or returned. So we have another principles, and we can go more detail, like due process, and user notification. That we were talking about the problems about the lack of transparency, the lack of transparency for the user to be able to defend themselves, find a lawyer to represent them if the companies by law are forbidden to notify the user. And more transparency about the use of government surveillance. As I mentioned, we praise Google and Twitter for disclosing these government reports, but it's not enough. We need much more information, and government should be able to also provide the data with more granularity, as long as, yeah. And then oversight principle, like there should be an independent oversight mechanism to ensure the transparency and the government access to our data. So there is, and then the cost. We have about the integrity of communications and systems, which is another principle that tries to say, please don't create backdoors to your system because you are making your system more weaker. Mandatory backdoors, lawful interceptions is just weaken security, and companies should have the obligation to provide secure software. And then we also see a lot of problems of law enforcement cooperation among countries. For instance, some countries are saying, oh, we don't want to comply with the mutual legal assistance treaty between one country and another one that says that you have to implement due process through the treaty. And they said it's too slow, so let's pressure the company if they have an office in that country, make them hand over the data without passing through this international treaty cooperation. So we need to make sure that there are due process implemented, and the process that you're using is the one that provides a higher standard among both countries, and not use this cooperation to undermine existing legal protections that some citizens might have under their own law. And then we want to prevent illegitimate access. We want governments to ensure that law enforcement who initiate or are complete should not be complicit on unnecessary, disproportionate, or extra-legal intercept or access to our data without having the penalties. For instance, there are some legislation that will provide a liability regime if the company hand over, for instance, voluntarily the data to the data. Okay, I have it. Okay, and finally we have the cost of surveillance. The cost to access the data by powers authorities is a company charge for the data and we put constraints, we are creating first governments will have to create an admin paperwork that allow have budget to request this data to companies. But so we want them to actually cost and not be free, so they can ask whatever they want, all the requests they want without having some constraints for doing so. I think I am going now to the questions and read the chat. Okay, thank you, Ginger. Well, depends on what you use. For instance, if you're using Dropbox, you know, it's a company, it's a cloud service that allow you to host, store your files. I would suggest that you encrypt the data before you upload your information to the cloud. This is something you can use in your end if you know how to use encryption. EFS has developed a tutorial of how to encrypt your data in EFS website. It's called Surveillance Self-Defense International. And there are other organizations like Tactical Tech that teach you how to secure or encrypt your communications. Unfortunately, some cloud providers does not allow you to do so. They are using now HTTPS, so your login could be protected. However, your content of communications are not encrypted, and the company itself can access the data. And they want that. Their business model, because they want to mine that data for advertisement, and the business model are not, they don't have an incentive to encrypt that data. So only, but that's your Gmail, and so you need it, and so you have that. You can always not use cloud computing, encrypt your data with PGP in your traditional email. So we always say you need to do your risk assessment. Your threat, because if I'm a user in a authoritarian regime, I might not care that the US government has access to my own data, and I might want to use Gmail, while if I am in the United States or I am a supporter of WikiLeaks, I might be more cautious of using Gmail because it's subject to US jurisdiction. Thanks, Stephanie, for your question. As I mentioned, yes, as I mentioned earlier, that's the problem. For cloud services, there are free services. They don't encrypt the data, and they don't encrypt them because they want to mine the data to use it for advertisements. So we became kind of the product for the company to mine our data. So yeah, that's happening in some cloud providers. There are several kinds of clouds, so it all depends whether it's a web-based provider or it's a storage, when you have more control over these services. You can encrypt your data, and then they won't be able to access it. Well, this is two things. First, one by one. One is the well, I'm talking about the use of cloud computing, whether it's storage like Dropbox. I'm talking there about content and your files when you can encrypt. And then I put another example about your webmail when it's secure because it uses HTTPS. but your data is still mine, collected by the company, and the company still has access to that. They will have access to the content, and they want to have access to the content of your communications, so they can provide you with more targeted, and your metadata from where you are connecting it, both. So they can provide you with more targeted advertisement, like I'm in Canada, so I will provide you, my IP address will disclose my location, and I want ads from that country on specific services, because in my email I'm saying that I'm going on vacations, to Ottawa. And so they use that information of the content of communication and your metadata both to provide you with a targeted advertisement. We said, hey, we want your email encrypted, I don't want even those companies to read my webmail. I just want to have control over that. But that's not possible. And there are no incentives for those companies to provide that services, because they need to mine information, because it's part of their business model to provide advertisement. While there are other companies, other kind of cloud computing that I was mentioning, that allow you to encrypt your data if you are storing it. So you just have your file of your whatever file you want to make a backup in Dropbox. You encrypt it with a special tool, and then you upload the file on the internet. Term of services. Well, to be honest, I read term of services, some of them, especially just because I'm curious, but I think, and I work on this, but I don't think the majority of people really read the agreements. Mainly the agreements are a disclosure of liability instead of a protection of your rights. And disclosure, the liability, a disclosure of liability for the company, and instead of protecting your rights as a user. I don't know if I replied to your question, Ginger. Yes, this is true. That's true, but that's why it's important that there are privacy laws in some countries. For instance, in the European Union, they have a baseline of privacy protection. Any company that has to comply with European legislation has to create a term of services that, at minimum, respect that baseline privacy protection. However, in other countries, like the United States, where all the companies that provide services around the world are located, does not have this kind of legislation. It's sectorial law, and it's a different model. So there is a weaknesses there on the level of protections or enforcement. Still, the consumer agency in the United States, is very strong. If the privacy policy change, having what's this? A deceptive practice, then the FTC can challenge that company, but it's not so general as in European. Although the fines of the FTC are very, very large if they fine a company. And yes, sometimes I guess we read and we don't link on it. Some of them, yes. But still, some companies are not subject to the jurisdiction of that legislation, Some groups from civil society a few years ago were talking about the need of global privacy standards for a global world, because our data is flowing from country to country that are subject to the legislation of different countries. And this creates a huge problem for the companies that you are one company, but you have to comply with the laws of all the countries for the same services, and each of them different rules, requirements that even contradict themselves. And so that's like a necessary burden. You want a strong protection, the higher whatever it is. At the same time, not all countries have data protection, so you create some for data heaven where you can just be subject to the legislation of countries that does not provide a strong privacy protection. So in that meeting, which was the Data Protection Commissioner meeting organized in a few years back in Madrid, civil society issued the Privacy Madrid Declaration, in where they were called, some civil society groups. I was not working in EFF in that moment, but they were calling for global privacy standards for a global world. Any other questions? I think I replied about the European Union and the US already. Is there any other question after the last one from Stephanie, or should I? Oh, yes, there is one more. Well, I mean, there are different things, you know, but the things that we are right now trying to fix is this, the fact that governments around the world are asking the data of of internet users to companies that are now handling our data, a vast amount of information about ourselves through the years. And those laws are not strong and nor are providing a strong privacy protection vis-a-vis those governments. And so for myself, because I'm working on that, and so I think it's a hot topic, priority issue, is the fact that the need for international due process standards that provide a strong legal safeguard for government access to the data in more detailed way. This is a challenge because surveillance compared to consumer privacy is more secret and secrecy, and we don't know exactly what's going on and how the data is being used or mined, and it's much more, and government seems not so much interested on work on this topic. So we are trying to advocate for the now that we are living just touch my data much more than many years ago, that this kind of protection is needed. Well, I don't. I think companies. I don't believe in tech mandates compel tech companies what they have to do. I think I will pressure them to do it, and they should be able to do it. And we will change them, or I will use another system, and I will go and use another system. There might be reasons or not. There should be more, I believe, more on the competition among companies, on competition pro-privacy, you know. There are little work or a little development on pro-privacy companies. I think that innovation on pro-privacy companies needs to flourish. But no, the models of business model right now, it's all the contrary. Disclose more data, give me all your data. So we need ways that, I think there is a market for encrypted communications and content. But you know, depending on the country, if you are in a low bandwidth, you might not be able to use even cloud, or encryption will make it really slow. So you cannot compel that. It's different realities, and that's why I think it's very complicated. Okay. There is no specific legislation on cloud computing in land countries, but there is a new trend in Latin America, Uruguay, Peru, Panama, Costa Rica, about government access to even Brazil data online. The trend is that governments are trying to get rid of the court orders for access to the data, and that implies data on the cloud. So what we need to be fighting for is for those principles to be implemented and to make sure that those standards are not overridden or deleted. But you need a court order to access to our data online. So you will not see a legislation specifically on cloud computing. What you will see is criminal law that will get rid of the safeguards that traditionally we have had, like a good order under reasonable grounds, and that is happening, you know. So we should make sure that those laws don't override our rights, and we should assess these bills or laws against the principles that we are working on, because it will give you a guidance to know whether the legislation is going far beyond international law or not, and the mechanisms you can use to challenge those bills and convince governments to change those bills. Of course, this is a general principle, but we hope to the coalition and the several organizations that are working on that hope to develop more guidance to privacy advocates in the future. I'm not following Wiki, so I don't know what's the latest leaks about it, but my concern on Wiki was on the cybersecurity front, at least with the earlier draft. There were a lot of provisions that compel states, especially from Russia and other countries, that compel new cybersecurity obligations. And I don't think the ITU is the right venue to discuss those issues. Per se, as civil society, cybersecurity, while can have legitimate aims, it's a complicated topic because it raises a core privacy and human rights implications. So I would prefer to discuss it in a forum where I know a strong human rights protections are embedded. Well, it's beneficial to use those systems. I said cloud computing is excellent for that, but of course, you as a government don't want to rely on third parties to disclose your state secrets. So I would prefer to encrypt my data and my communications if I were a government. And there are free tools that allow you to do so with free software and other encryptions. But maybe small states need to communicate with local free software community or the technical in their country to be able to set up the system, because it's not as easy as all the benefits that cloud computing can provide, you know. So for me, it's great that I don't have to call I have to reply to my mother at 2 a.m. in the morning how to install their new operating system, because she just deleted the email and destroyed the computer, the operating system, and because there were a virus and lost all his data. I mean, it's great, and now you have this Gmail, you know, and you can just go to the Gmail and have all your data. But as a small company, as a small state, and as a state in general, I will be more reluctant to rely on third parties to store my data instead of having encrypted them in my own server. But that might cost, and that will be complicated, and there might be new innovative ways to handle that, perhaps with the technical community of that country. It's not an easy answer, sorry. Yeah, I'm sorry. I wish I could have a better answer, but I think it's not as easy as. Okay, I was answering a private comment, I think, but Christina told me I think nobody read the question. Is there any other question? That's all. Thank you. Virtual applause. I hope I was clear enough that you enjoyed the presentation. Hope to see you soon in the future. Thank you for attending the chat. Nice meeting you. Thank you, everyone, Christina, Fatima, Ginger, Stephanie, Arvin, Anya, and everyone. Nice meeting you. Next time, I need to see the faces of all of you. So I know it would be nice to see their faces and see who are in the other line. Feel a little strange talking to my laptop, but I'm reading at least. Okay, bye-bye. Nice seeing you all. Okay, thank you. Bye.